Today's webinar is an introduction to immigration billing of controlled work matters. The webinar is going to cover the basics of what needs to be reported in your CWA submission in the immigration category. By the end of the webinar, you should understand the difference between your new matter start reporting and your outcome reporting, how to report your NMS data against the correct procurement area and office schedule, how to identify which codes and cost information should be used when reporting your claims for costs, what claims can be made at different stages of a case, and what information needs to be reported. There'll also be detail as to how and when to request amendments to previous submissions. So the session is not a replacement for your consideration of the published guidance on reporting submissions, and it's also not going to cover the generic guidance on how to access CWA and the detail of how to make a line-by-line or bulk load submission. So we'll start with the types of submission. So there are two types that you're required to make through CWA each month. This is a submission regarding your new matter start usage in that month, and a submission regarding the outcomes for cases that are concluded in that month. Submissions are made a month in arrears. So for instance, if you're making your submission for the month of September, that will be submitted in October, and you'll have from between the 1st to the 20th of October to submit that reporting to us. Once the submission has been submitted, then no new outcomes can be added to it. If you don't have any work to report, then you still need to complete a monthly submission, and you should provide a nil submission. If you don't put in a submission, then you'll find that in later months when you go to make your submission, you won't be able to until you've put in some form of submission for this earlier missed month. Reporting new matter start usage. So you may open a combination of legal help and controlled legal representation matter starts during any month, but when you undertake your reporting to us each month, you should report the total overall number opened in that month against each of your schedule authorizations. So for instance, you have an office that's within the Midlands and East of England procurement area, and in September, you've opened 20 legal help matters and 5 CLR matters from that office, in which case, when you come to make your submission, you should report a total of 25 matters against that authorization. All of your immigration matter starts are allocated under the category code IMMAS. So when you're reporting usage, you should ensure that they're all reported against that code. You'll see that there is the option of an IMMOT code. Please ignore that. You don't need to use that when you're reporting your NMS submission. If you hold authorizations under the Detained Duty Advice scheme or the Detained Asylum Casework scheme, you'll have separate NMS allocations for each centre and each scheme, and you'll need to report these matters open against these on different lines of your submission. So you can choose to either report the data directly into CWA, or you can choose to do it via the bulk load spreadsheet. So you'll see on the slide here, we have a screenshot from the bulk load spreadsheet, and you can see the various fields that you need to complete. So your schedule reference is unique to each office, and it's in the format account number / year of the contract. So in this case, 2024 / your schedule number, in this case, 01. So the procurement area and access points should match those that are set out on your schedule. For instance, if you open an immigration matter from an office in the Midlands of East of England procurement area, but the client is in Liverpool, it's the Midlands and East of England procurement area that you need to report the matter start against. You must enter a line for each authorization you have from that office where a matter start has been opened. So to give you a bit of an example, the table at the top there is from your contract schedule, and you'll see that each line there sets out a separate contract authorization. So in this instance, the provider has authorisations for the Midlands and East of England, and it has various authorisations for the Detained Duty Advice Scheme, with each individual IRC listed there with a separate matter start authorisation against it. The second screenshot then shows you how that would look if you then translate that to submitting your NMS information each month. So each line there relates to a different procurement area authorization. So the second line there, for instance, where there's 25 matter starts reported, that procurement area code relates to the Midlands and East of England procurement area. So in this instance, the provider is telling us how many matter starts they opened in that previous month against each of those authorizations. You'll see when you come to report your NMS that there's a CLR table. This is essentially a redundant report that you no longer need to complete. You'll need to enter a 0 against each of the fields just to allow you to progress through the reporting, but there's no need to worry about recording any information here or what this may relate to. It is something we're looking to remove from reporting, but for the moment, you just need to enter zeros against each of the rows and then move on through your submission. So the second part we're going to look at are reporting your outcome claims under controlled work. So these are essentially your claims for costs for matters that have concluded in that month. Those of you that held 2018 contracts or contracts indeed prior to that point will be aware that historically legal help and CLR were part of the same matter start, and providers could stage bill at the end of legal help if moving on to CLR. That changed in April 2023, and for those of you starting under the 2024 contract, stage claims are not something you will need to make other than in bail matters. So there are various different claim types for you to choose from when you're making your submission. You've got your completed claims, which are going to be the majority of the claims you're going to be making. There are the options for stage disbursement claims. So we'll touch on these more in a moment. And then for those older matters, you've also got stage claims. Depending on which type of claim you choose, different fields will need to be completed and will present themselves on CWA. For instance, if you're submitting a stage disbursement claim where all you're claiming are disbursements, then you cannot claim any profit costs, and any fields relating to that will be grayed out in the bulk load spreadsheet or just won't be available to you in CWA. It's worth noting that there should only be one completed claim per matter, the exception being where bail advice has been claimed, and you can claim separately for that from the substantive matter. It's important to remember that where you identify that costs have been omitted from a claim or an error is made with the claim, you must request a claim amendment. Do not submit a second claim for the additional costs, as that may trigger a second payment of a fee which is not actually due to you. Stage disbursement claims can be made in accordance with the 2024 contract. In essence, this allows you to make a claim where the matter's been open for at least 3 months and you've not previously billed those costs. At that point, you can make a claim for any disbursements you've incurred to date. The same may apply that if the matter carries on and for a further 3 months and you've incurred further disbursements, you can then put in a further stage disbursement claim. So you may be putting these claims in once every 3 months, depending how long the case progresses. You should only report the disbursement costs that you incurred since the previous claim was made on that matter, and you need to ensure that the overall disbursement value incurred doesn't exceed any applicable cost limitation. You may find that CWA may reject or may cap a claim if the total disbursements reported in any one claim exceeds the initial cost limitation and you've not provided a prior authority number. So for instance, if you have a legal help matter where the disbursement limit is £400 and in your stage disbursement submission you've reported £500 of costs but have not entered a prior authority number to demonstrate that you're able to exceed the limit, that claim may well be rejected for that reason. You also need to ensure that no costs are repeated across the claims. So if you've already submitted claims for a disbursement in a stage disbursement claim, you need to ensure that that disbursement does not then appear in any subsequent claim. Legal help and CLR are now separate matters, and as such, separate claims should be made for each. If both matters were opened under the 2024 contract, then they should both be submitted as completed claims. The contract sets out when claims can be made, and I'd refer you to those paragraphs indicated on the slides. As with reporting your NMS, when you're reporting your submissions for outcomes, you need to report the claim against a procurement area and access point combination. And the same rules apply here as they did with the NMS, that it's not about where the client was located, it's about which office and authorization the claim is linked to. So again, if for instance you had a client who was in Liverpool, but your office was in the Midlands and East of England procurement area, which is what is on your office schedule, then it's the Midlands and East of England procurement area that should be reported against that claim. Now, within the provisions of the contract, there is the ability for a provider to submit an early claim or to put in a claim prior to the completion of the matter, but where they're continuing to act for that client. In general, you can only submit a claim prior to the conclusion of the matter where that case is still continuing and in certain prescribed instances. For example, in asylum matters where an interview has been attended and you're awaiting a decision, or if a fresh claim for asylum has been submitted and you're awaiting a decision, then in those instances, you can make a claim at that point for the cost that you've incurred to date. You should note, though, that if you then continue under legal help to incur any further costs on that matter, you should not submit a further claim, but you should request a claim amendment to that early bill to add in any additional costs that may be due to you. And as set out on the slide, these claims would be completed claims, and you should use the outcome code IY, which indicates to us that a third-party decision is awaited. When reporting your outcome claims, there are different code combinations that may be available to you depending on the type of case that you've undertaken and depending on which type of fee you're looking to claim. The most important of these is the matter type 1 code. This code tells us which fee scheme the matter was funded under, standard fee or hourly rates. It also tells us whether the claim relates to legal help or CLR, asylum or immigration. So it's really important that you understand which of the code combinations could apply in any situation. So you'll see there that there are 4 basic codes that you should be aware of in relation to the standard fee scheme. And then for hourly rates, in general, the claims you're going to be making there would fall under one of those 3 claims. A helpful set of tips to help you understand at a glance what those codes may mean. If the second letter of the code has an A, then it refers to asylum. If it has an M, then it refers to immigration. If the code contains an L, then it relates to legal help. If the code contains a C, then it relates to CLR. So straight away, depending on what type of claim you're looking to make, you'll be left with a limited number of options open to you. The matter type 2 code then goes on to tell us more about the type of case that the client sought advice on. For example, was the claim relating to an application for asylum, an extension of leave, an application under domestic violence provisions, or maybe an application for bail? What you'll find is that CWA has some validation, which means that certain matter type 2 codes can only be used in conjunction with certain matter type 1 codes. And you'll find that CWA will reject claims where incompatible combinations have been quoted. So the example we have here is that all matters relating to unaccompanied asylum-seeking children are payable under hourly rates. Therefore, you cannot use a standard fee matter type 1 code with the matter type 2 code IUAS. You also need to report the outcome code to us, and this is indicating to us that at the point of submission of the claim, this is the outcome that you've achieved for the client in that case. Outcome codes IA to IG should be used where the outcome of the client's matter is known. Outcome codes IT to IZ should be used where the ultimate outcome of the matter for the client is not known. So this may be, for instance, because you're submitting an early bill and you're waiting for a third-party decision, or it may be that the client has ceased to instruct and you don't ultimately know what happened with the outcome of their claim. In standard fee matters, the profit cost field is one that providers can often misunderstand what is the purpose of it. In standard fee matters, you should enter here the value of the work undertaken had it been incurred at the applicable escape fee hourly rate. So we're not looking for you to enter the value of the fee that you're due to be paid. That fee will be generated and credited by the matter type 1 that you've used. You need to put in here the value of the work undertaken so that CWA can then use those figures to calculate whether the case is an escape fee case. So have those costs pass the threshold that's in place for that type of claim. So for your profit costs, you enter your costs in there. For matters under CLR where potentially counsel has incurred the costs, then again you undertake exactly the same approach. You report the value of the work undertaken by counsel if claimed at the hourly rates in the counsel fee field. Under the standard fee scheme, there are also additional payments that may be due to you. These may be for attending a Home Office interview or attending a particular type of hearing under CLR. Most of these additional payments are available in multiples. So you could potentially, for instance, attend multiple oral CMRHs, or you may have hearings that are adjourned more than once, in which case you can claim multiples of the applicable fee. You are only able, though, to accept one payment of a substantive hearing fee, and in that field you have to enter yes or no, and the fee will be credited to you. CWA will then add the value of these additional payments to the overall value of the claim, and they also factor in to the escape fee calculation. There are some costs that you may incur on a standard fee matter which aren't covered by the standard fees themselves. So this would likely be any costs for you traveling to see the client as they're in detention, or where you have some advice given in relation to potential judicial review, pre-action protocol advice, for instance. None of the costs of these two activities are factored into the standard fee. In both instances, these costs can be claimed under hourly rates, and they will be added to the value of the fees due to you under the standard fee scheme. There are two separate fields, and you can enter the costs incurred at the hourly rates in these fields. Please note that for the JR related costs, these are subject to a cost limitation. The situation is slightly different when reporting hourly rates matters, as the entire point here is you're going to be paid the cost that you've actually incurred. There's not a set fee for these. So when you've used the hourly rate matter type 1, that will tell CWA that you should be credited the amounts that you put in the profit costs and the counsel fee fields. So when you come to report your profit costs, then you should enter the value of the costs undertaken at the applicable hourly rate, and the same applies for the counsel fee information. You should ensure that you only claim up to the value of any authorised cost limit, and that if you have authority to exceed the cost limit, that this is reflected in the use of the prior authority number in the field of the same name. As the detention, travel and waiting and JR costs are also paid at hourly rates, in this instance, there's no need to separate those out. They will form part of the profit cost that you report to us. So you may find that those fields are not available for completion, or if you do complete them, that the amounts entered won't be credited to your claim. They should instead be included in your profit costs. There are some fields in CWA which alert us to the fact that the matter you're attempting to claim is one that ordinarily would be out of scope. So it may be that you've applied for exceptional case funding and that's been granted, in which case you would have been allocated an exceptional case reference number. Now, when reporting this matter, as the matter would usually be out of scope, the code combinations that sit in CWA would usually be unavailable to you unless you enter the exceptional case reference number. When you enter that number, CWA will then accept these combinations that ordinarily it would refuse. Aside from exceptional case funding, there are matters that are brought back into scope depending on the circumstances of the client. So these are exemptions rather than exceptional cases. So there's a separate field for these, and depending on the reason for the case being brought back into scope, there are certain codes that you enter, and again that will allow these otherwise unavailable code combinations for matter type 1s and 2s to be available to you. The most common exemptions are going to be that the matter is brought back into scope due to the client being a victim of trafficking or modern slavery, or the second will be that they are a separated migrant child. If you refer to the guidance for reporting controlled work, you'll see, I think it's in section 14, that there's a table that sets out all of the various exemption codes, and you'll find the codes for these scenarios in that document. We're now going to turn into how you can amend any submissions that you've already made. Now, there is a variety of reasons why you may need to make an amendment. It could be because you've realised you've reported an incorrect number of matter starts opened in a month, or it might be that you realised you've used the wrong matter type 1 code and that's generated payment under the wrong fee scheme. It could be, as we've mentioned earlier, that you've submitted an early bill and now you need to add in any additional costs and amend the outcome. Or it could be that you've forgotten to include a disbursement in your completed claim outcome. It may also be the case that we have requested an amendment to a claim because of an error that's been identified on audit. When making your NMS amendment, you should refer to the claim amendment form and select the Civil NMS tab. You'll see a screenshot of the form provided below. In this instance, you'll see that it reflects the bulk load spreadsheet that you may have filled in, or it will reflect what you see on CWA when you initially go in to put your NMS submission. You need to provide the details regarding your account number, your provider name. You need to highlight to us the month of the submission that you're seeking to amend, the category, your schedule reference and procurement area and access point. And then in the final fields, you're telling us here the number that you originally reported in that submission, and then the matter start number that you wish to change it to. So in this instance, the provider, Blogs & Co, has realised that in the month of September 2024, he initially reported 25 matters. It should have been 15. And you'll see then that that will lead to an amendment reducing that matter start total by 10. Once you've completed the form, you should email it to our claim amendment team at the email address on the slide. They will then process that amendment and confirm the details to you. It's a very similar process for your outcome amendments. It's the same claim amendment form, but you need to select the Civil Amendments tab. For these claim amendments, what you need to do here is in the fields to the left-hand side, which are highlighted in yellow, you need to provide us with these details so that colleagues can then identify the line of the submission. And then the fields in blue, you don't need to complete all of these, you just need to complete the fields where you're seeking to make an amendment. So in this instance, the provider has realised that it's got additional disbursements and profit costs to add in. And you'll see there that it's completed those fields with revised figures, and that has led to the value of the fee increasing from £650 to just over £1,200. So you don't need to put in any further information in the rest of those fields. You then email the form to the claim amendment team. They will then process that amendment. They'll contact you if there's any missing information or any information that causes difficulty in being able to make the amendment. And what you'll also receive is a notification via CWA when any amendment to a claim is made. In terms of when you'll financially feel the difference of that amendment, if, for instance, this is a claim that was made in September 2024, and you request that amendment, say before the 20th of November, then what you'll find is the additional credit here of £567.50 will be added to your December contract payment. So that brings us to the end of the webinar. We're just going to finish here with some useful links and contact details that you should be aware of. These include the actual contract documentations, the regulations themselves, the guidance on how to make controlled work claims, and then you'll also find on our learning website a set of key cards which are discrete topic specific pieces of guidance that cover some of the issues we've discussed today, including early billing and also around CLR and MatterStart usage. You'll find the links to where you can find the claim amendment forms, and there's also a link to a useful information document for those of you that are joining us under the 2024 contract. If you need further support, I'd also refer you to our training website. You'll find there the web chat function to allow you to interact with colleagues in our online support team should you have any technical difficulties when you're trying to make one of these submissions. And if you've got a desire to kind of find out more about different topics, you'll find further webinar recordings on our training website as well. And if you don't already, I'd suggest that you sign up to our Legal Aid Bulletin, and you'll receive e-alerts containing links to various news stories and updates to relevant pages. And you can obviously follow us on social media as well.